In this video, I'll be sharing with you how to move the court for an adjournment. If you're watching this video and you're a new week, you find yourself in a situation whereby a case file has been assigned to you to go to the court and pick a date, like an adjournment date. When I started practicing as well, in the first few months, I found myself in this situation. A case file was given to me to proceed to the court and give certain reasons why we cannot proceed on that particular day and pick a date, like an adjournment. And I did it, but there were little mistakes here and there because I could not get anyone, or probably I did not seek for help. Okay, and that is why I'm making this video. So to start with, what is the meaning of why do we seek an adjournment in court? Sometimes probably your witness is not available, or the case file, you are yet to peruse the case file, or probably your principal who is abreast with the fact of the case is not available to appear in court. So for reasons like that, you often find a counsel, a lawyer, go to court and pick a date for adjournment. So how can you do this to achieve the best result, so that the court will not see you as a young lawyer? The way the legal system works in Nigeria, we don't complete a case and finish it on that same day. As a lawyer, you're watching this video, you already know that there is a time for mention, there is a stage for hearing, there is a time that it will come for the lawyers to give a final address on the subject matter. So there are stages. So definitely there would be adjournments. That is, the day will come, you go to the court to mention your case, or probably for hearing, and you adjourn for the other party to also bring their witnesses to court and all of those things. So adjournment is very much necessary in the legal system in Nigeria, because you can't go to court on that day, like I mentioned, and finished on that day. There are a lot of other cases that the judge will need to listen to or to hear. Okay, so that is why we pick adjournment. But this is for you that the business of the day will not proceed. A case file has been assigned to you as a new week. This happened a lot to new weeks. Anytime a law firm sees that a case will not proceed on a particular day, the principal will not bother to go. It may just be in his office and write a letter of adjournment. And there are authorities now that adjournment letter should be filed, properly filed. So in a situation whereby probably there is no time to do that, your principal may choose to send you to court to pick a date. So in that situation, probably matter is adjourned for hearing, and no witness. You're not going to do anything, you're just there to pick a date. So in this situation, you need to persuade the courts. There are some courts that they don't want to listen to that, although many courts will give you a benefit of doubt, particularly if your law firm has been up and doing, about the case, always coming to court, doing everything that ought to be done. So in such situation, the court will give you that privilege to pick a date. But there is how can I put it now? There is a way you need to do that for the court to grant your application. First thing, when you get to court, you announce your appearance. So let me, I am here as a plaintiff counsel. Okay, so I will announce my appearance. May it please this honorable court, MD or Dedele. My humble appearance is for the plaintiff. So I will take a bow and sit. I will allow the other party, if they are present in court, to announce their appearance. And when that is done, as a plaintiff, I should be the one to inform the court of the business of the day. So, my lord, the matter is adjourned or is slated for hearing. However, my lord, we will most humbly apply to the court for a short adjournment. My lord, my principal, who is very much abreast of the fact of this case, is before your learned senior brother in court 5, and as such cannot be present in this court to proceed with the business of the day. My lord, I have informed the lawyer on the other side about this situation. We will be seeking the court for a very short adjournment. We are most grateful, sir. We apologize for any inconvenience this may have caused the courts. We are most grateful, sir. So the court may ask you some questions. Oh, before which court? Just make sure you have the response, okay? There is this hierarchy of courts. So, for example, I was in a particular court the other time and I could not proceed because I needed the other party, who is very much abreast with the fact of the case, to be with me, and it could not meet up. So I just had to pick a date, and my reason basically was I basically informed the court that the other person was before another court, which I was in court 25, and the other person was in court 12. So, there is this hierarchy of court. The court 1 is actually the CJ's court. So imagine if you have a matter in the CJ's court and you have another matter in court 25. What the law sees is that there is seniority. So you are expected to be before court 1. So if you can't meet with court 25, it's okay, provided that you're sure you're before court 1, because some courts may do that part to investigate if truly you or the other person actually was before the other court. Okay, so that's because we just asked you a few questions. Which matter, why is it not in court? Make sure that you have the facts, the responses that you need to give to the court. Also, the court will ask the other person if the other person is objecting. So that is why it is quite okay that you try to look for the other counsel. Okay, check the court's list, check if the other counsel, if the name of the other counsel is on the list, and ask, please, who is let's say AS Adekunle. Just ask here and there. You can't make a broadcast like to call everyone attention in the courtroom before the court starts sitting, obviously. Okay, so that is one of the reasons. This is one of the reasons why you need to be in court early enough. Okay, so, and if you don't want to do that, you can proceed from a lawyer to another lawyer. Like, please, are you in this matter? Are you in this matter? And if peradventure you are not in court, like the court is already sitting before you enter, just find a way to ask people around, are you in this matter? Are you in this matter? And if you can't find the person, it's okay. Probably he or she is not in court, but it will be good if you can speak to the other person. So in my own case that happened some days ago, I informed the prosecution that most likely we will not proceed with the matter, and it was like, it did not give me a yes or a no actually. And when our matter was called, immediately he told his witness to proceed to the witness court, even before the court gives that permission, because he wanted it to be like hot, like I don't even know the best way to put it, but at the point he objected to my application, and this is the point you need to use if your application for adjournment is being objected by the other person. So what I did on that day is to make the court to know the antecedent of the matter, that we have been always, every adjourned date since the case file, since we started representing our client, that we have always been in court. So that was the fact. So, and that is why you need to have your case file and go through it. I have a video already on my YouTube channel, reason why you need to be in court early, like how to prepare for your case. So that was even my first time appearing in that matter. So, but what I did is I went through the case file, the notes on the case file, and I made the court understand, my lord, this was the time we got this brief. This was the date of our first appearance, and ever since that appearance, we have always been before the court. And the court checked through the court's record, and the court affirmed that my position was correct, and that was why the court granted my adjournment, granted my request, and as well did not order cost, because the other counsel objected and requested for about 250,000 naira cost. So if that happened, what do you think you would do? You won't just sit down. You will tell the court that, my lord, we are objecting to the request of the other counsel. We are not conceding to any cost. My lord, since the inception of this matter, we have always been in court. Give your facts for the court to know that you or your firm has been punctual over the case, and this is the first time that you'll be coming to court to seek an adjournment. And peradventure, you have sought for an adjournment before that time. Still make the court to know that you have been up and doing on the last adjourn date you made, or the effort you made, so that the matter, the business of that day could proceed. Just make the court to understand that, and make the court to also know that you are not conceding to cost. So I know the courts would use its discretion to give a ruling. I hope this video educates you. Please like, subscribe, and share. Thank you, and I will see you in my next one. Bye.